I want to welcome you all to the session entitled The Creeping Federalization of Corporate Governance Law, the Dodd-Frank Bill. And I should introduce myself first. I'm Larry Hamermesh, and although my usual profession is teaching at law school at Widener University in Delaware for 18 months, including the present, I'm tasked to the Securities and Exchange Commission and the Division of Corporation Finance Office of Chief Counsel, which is why I'm also required to say, as Commissioner Atkins well remembers, that whatever opinion I express here, and I hope not to express any, is purely my own and not that of the Commissioner or any of the Commissioners or any of the other members of the Commission staff. But the rest of the folks who are going to speak here undoubtedly have opinions. It's a pleasure to be here with such an esteemed group of participants. Let me just introduce them very briefly and turn it over to them for some opening comments to be followed by some discussion and then an opportunity to have some questions and maybe answers from up here, questions from the floor, and maybe some answers from up here. So what I'll do is introduce them in the order in which they'll be speaking. I'll start on my far right, your left, with Sarah Teslik. I'm not going to say much about any of these people because they're so well known, but very briefly, Sarah is the Senior Vice President of Policy and Governance for Apache Corporation, a large energy firm based in Houston, and she's been there for 4 years, I understand, and before that was for 19 years the Executive Director of the Council of Institutional Investors. An interesting perspective, both of them. Jeff Mahoney, who's next to her, is currently with the Council of Institutional Investors, has been there for 4 years or so as General Counsel, and is also from the same cut of cloth as I am because he teaches at American University Washington College of Law. On my left, immediate left to your immediate right, is Paul Atkins, Managing Director of Patomak Partners, LLC, consulting services provider in the financial services industry. I suspect he's more widely known as having been commissioner, member of the commission, Securities and Exchange Commission from 2002 to 2008. More recently, and perhaps lesser known, was a member of the Congressional Oversight Panel for the Troubled Asset Relief Program, or TARP. And then finally, on my far left, your far right, Brandon Rees, who is the Deputy Director of the Office of Investment of the ALF-CIO. And his short biography includes the very striking fact that union-sponsored pension and employee benefit funds hold approximately $480 billion, that's billion, in assets, which is still a lot of money where I come from. In any event, let's begin with some opening comments from our panelists. The broad question that we're discussing here under the heading of Creeping Federalization of Corporate Governance is really twofold. It's first of all whether recent changes in the form of the Dodd-Frank Act are good things or bad things, but more broadly, and particularly appropriate to a group interested in federalism, whether they represent a significant positive or negative change in the relation between state law and federal law as it relates to corporate governance. So Sarah, do you want to start us off?
Sure. I'm sure the irony is not lost on any of you that this session on creeping federalism is being chaired by a prominent Delaware lawyer who has been bagged by the SEC. Game over. I have 6 minutes, and I will make 6 points in 6 minutes. When people discuss the creeping federalism or the contest between state and federal law in the corporate area, they are often talking about different things, and you have a ships passing in the night feeling as you listen to the conversation. So I think it's important, as we have this discussion, to try to listen to which of these 6 contrasts the various panelists are talking about. The most obvious one is simply the debate over whether it's better to have one regulator or 50 regulators. And you've heard all of the arguments that one gives you uniformity, it's a global world, it's too fractured to have 50, that 50 gives you 50 little experimental melting pots of corporate law, so there's creativity. So there's essentially the debate about whether 1 or 50 is a better way to regulate. Yeah, the second thing that people tend to mean when they are having a discussion of creeping federalism is whether we are getting away from constitutional purity. In other words, it's not whether what is happening today is good or bad, is it consistent with what the Founding Fathers intended, whether or not what they intended is good for us today. And so that you see a lot of articles written on the constitutional purity question. The third thing that people tend to lump under the category of creeping federalism is not really one about principle. It's really a practical one about the content. You have people arguing for a greater state role because they think the states will will make substantive decisions that they like better, and people plumping for a more federal role because they think they have a better ability to influence the feds. And certainly if you look in the last 20 years, an entity like the Council of Institutional Investors has had a lot easier time influencing the feds than the states, in part because it is one and not 50. And there's certainly been debate over whether the inherently smaller state bodies are more easily dominated by local interests, for example, local corporations. Although if you look at the changes in Delaware law in the last couple of years, it's not at all clear that the corporate advantage is what it used to be. So there's also really a use of creeping federalism to disguise a debate over which forum will give me what I want. The fourth is really a debate over whether it is possible to separate corporate and securities issues in any way workable between two bodies. It's taking a seamless web and tearing it apart. I remember in law school listening to my corporate law professor trying to explain that when a proxy is flying around in the air, the SEC is governing it when it goes out to the shareholder and it comes flying back, and the minute it lands inside the annual meeting, it becomes a ballot and it's governed by state law. And I'm having a hard time wrapping my head around how that works. So there's also, under creeping federalism, merely the discussion that we have two bodies competing for something that is increasingly seamless, and therefore that's a problem. Fifth is that there is captured under this heading a concern about the creep, which is, in other words, if you're going to move from one thing to another, you don't creep there. You decide you want to have state corporate law or federal governance law, but you don't creep. It's kind of like we don't want to creep to the metric system. We want to plump to the metric system. So there's really a debate about creep as opposed to which entity is better, and that's certainly a fair debate, especially right now. The last is, in a way, it's a content thing, but it's not a debate over is state law content better than federal law content. It is a concern that federal corporate law, federal governance law, is increasingly taking space not from the states but from the private sector. The decisions that we used to be comfortable being made by the private sector seem increasingly to be made by government. So people who are concerned about the creep are concerned that the more power you give the feds, the less room they give the private sector to operate. And there are certainly lots of examples of this. One of my favorites, now that I'm in the oil sector, is that we regularly get, because the SEC allows it, initiatives from various shareholders wanting us to be involved opposing child labor. And there are very few children on oil rigs. It's an issue, it's an important issue, it's not our issue. We are not a mini United Nations. We have to get oil out of the ground. If we had to be Congress and the United Nations at the same time, we do a really bad job of getting oil out of the ground. And there's other concerns like the creeping criminalization, not just of criminal acts, but of mistakes, accidents, other ways in which there's a concern that the federal government is more apt to step on private sector toes. So it's not really a state federal, it's a private sector federal. So I would just suggest, as we're going forward on this debate, and I'm stopping to stay within my 6 minutes to shame everyone else to doing the same thing, that we identify which one of these tensions we are talking about.
Thank you very much, Sarah. And as tempted as I am to respond, let me ask Jeff to address what he'd like to, which I understand is a little bit more specifically focused on Dodd-Frank and some of the initiatives there. So, go ahead.
Thank you very much. I very much appreciate the opportunity to participate on this panel. By way of an introduction, the Council of Institutional Investors is a nonpartisan not-for-profit association, represents public, union, and corporate pension funds from across the country. They have combined about $3 trillion invested in the capital markets. Our members are very diverse, and they share some very important characteristics as well. One is that they have a significant commitment to the U.S. capital markets. On average, our members invest about 60% of their portfolio in U.S. stocks and bonds. And second, they are long-term patient investors due to their long-term investment horizons, given their liabilities, and their heavy commitment to a passive investment strategy. Because our members are generally unable to exercise the Wall Street walk and sell their shares when they're dissatisfied with the company's performance, they have a deep interest in corporate governance issues. And that's why the council, and that's what the council's all about. That's what we do for them. We work with our members to try to improve U.S. corporate governance standards and strengthen shareholder rights and protections. With that brief background, it'd be no surprise to anyone in this room that the council has long endorsed a number of corporate governance reforms that are contained, at least in part, in the Dodd-Frank Act. Those provisions of the Act that address, at least in part, some of the long-standing council corporate governance best practices that have been approved by our membership include Section 971, which talks about reaffirming the SEC's authority to issue a proxy access rule, Section 972 involving disclosures regarding chairman and CEO, Section 951 on say-on pay and golden parachute payments, 952 on compensation committee independence and conflicts, Section 954 on clawbacks, recovery of erroneously awarded compensation, Section 955 on disclosure regarding employee director hedging, and finally Section 951 on eliminating uninstructed broker votes on compensation issues. Although not identical to council policy, we generally supported all the provisions I just mentioned because our board membership concluded, consistent with the views of Warren Buffett, the Investors Working Group, it was a blue ribbon panel chaired by Bill Donaldson and Arthur Levitt and many others, that one factor that contributed to the financial crisis was a failure of oversight. And that while we can probably, most of us agree that some more vigorous government oversight and regulation is appropriate, at least in some areas, we believe that a complementary and cost-effective and market-based approach to improving oversight at public companies is to empower share owners to hold board members more accountable for fulfilling their fiduciary obligations with respect to their oversight of company management. That accountability can be enhanced in a number of different ways, including by eliminating some of the long-standing barriers that inhibit the ability of share owners to exercise their fundamental rights to elect and remove directors. And the corporate governance provisions of Dodd-Frank that I mentioned earlier, particularly Section 971 relating to proxy access, I think a topic that Brandon's going to talk about some more in a few moments, we view as a very positive step to begin to remove some of those barriers and improve the effectiveness of the regulation of our financial markets and, importantly, to further enhance overall investor confidence in our capital market system. Thank you.
Thanks a lot, Jeff. Don't think we don't have more questions for you, though. Paul, Commissioner, whatever I'm supposed to call you.
Hey, you.
Hey, you.
Well, thank you very much. I mean, this is a huge topic, obviously, and one that I was intimately familiar with at the SEC, starting as I did about 10 days after Sarbanes-Oxley was signed into law. And so despite what I thought was going to be maybe kind of a less hectic schedule from having been a consultant going on to the commission, it turned out to be quite a busy one indeed, although I'm sure that now things are probably even busier than before with all the things coming out of Dodd-Frank. So what I wanted to do in the next few minutes is really give you a quick overview of how things have changed a lot since 2002, and even now, with especially in the wake of Sarbanes-Oxley and Dodd-Frank. You know, there is not a federal corporate code, and that's been debated for years and decades, basically. And back in the 1960s, when Bill Carey was chairman of the SEC, he actually advocated that there be a federal corporate code adopted because he viewed the 50 states out there as being inadequate protectors of shareholder rights. And there was a young professor at the time named Harvey Goldschmidt who became a commissioner with me in 2002 later on. But Harvey, back in 1964, wrote an article advocating how the federal government should have a statute that would require every corporation in the United States to have a 100% independent board, independent of management. And so, of course, those particular proposals were never adopted, or at least not yet. You know, with this particular congressional bent, who knows what might happen in the future. But at least then with Sarbanes-Oxley in the wake of Enron and WorldCom, of course you had this tremendous political pressure to try to have intervention in the corporate governance area. For the first time ever, I guess, the SEC became really an element in political races. My mother-in-law lives in Missouri, and she told me about some advertisements that were playing on television at the time in an off-year election, 2002, for the Missouri Senate race. And it was by this organization called MoveOn.org that we've all heard about. But anyway, it showed a fox chasing chickens or something like that. And it said, you know, who runs the Bush SEC, you know, the fox watching the chicken coop. And then there was another advertisement, also in Missouri and probably elsewhere, but it showed Ken Lay's face morphing into Harvey Pitt's face. Now, you know, my mother-in-law didn't know who Harvey Pitt was. I guess she did because I was, you know, had become a commissioner. But I dare say that most people in Missouri had no clue who that bearded fellow was on the television. But that just showed how, for the first time ever, you know, corporate responsibility became a political issue, or I guess at least some folks attempted to make it a political issue. And at least in that election, because after September 11th, national defense was really not an issue that the opposition party could run on. They were trying to elevate corporate responsibility into that. So what happened in the wake of Enron, and then which blew up in December or so of 2001, then you had the Senate, Senator Sarbanes, who was chairman of the Senate Banking Committee. He started to hold hearings, and Congressman Oxley in the House, who was chairman of the House Financial Services Committee, started to hold also parallel hearings as to, you know, what should be done with respect to corporate governance in the United States. And so it looked like nothing really was going to happen. There were discussions as to, you know, what the makeup of some kind of bill would be. And so finally, you know, not a lot of people were betting that something would finally come out of Congress until WorldCom blew up in the sort of early spring, mid-spring of 2002. And so it was getting dangerously close to the election. And so suddenly then folks in Congress got very concerned about what might happen to them, the results of the election. So they basically, you know, all the stops got pulled out. The Business Roundtable basically said that, well, we don't think Sarbanes's bill is so bad, which knocked the legs out from under Mike Oxley in the House. So then we had this law basically go quickly through Congress and get signed by the president in July of 2002. So Sarbanes-Oxley as such, I mean, there were a bunch of things that were added on the floor that sort of complicated it and that weren't really thought out very well. But on the whole, Sarbanes-Oxley looked to the states and kind of respected the division of as between the states and the federal government with respect to corporate governance. And for the most part, it either directed the SEC to then direct the stock exchanges to have, as a matter of their listing requirements, various things with respect to the board and the various committees of the board. And they, with one exception, that's really the audit committee, where basically it said that it should be made up of independent directors. But beyond that, the Congress respected this division. Now, there were some problems then that came out of, like, for example, the audit committee that no one really thought about in Congress because they were so intent on, the United States being the United States. They didn't think about what was, that we have foreign companies that are registered here in the U.S. And so there was this whole extraterritorial application of the U.S. law with respect to some of these issues, and among which were independent directors of audit committees, and where, for example, in Germany and Japan, by their organic law, it says that an audit committee and the board of a company must have employee representatives on the board, and so obviously they're not independent. So luckily, the Congress left enough latitude for the SEC for us to listen to those comments. The people in Europe were really freaked out about all that, and obviously, raised a bunch of ruckus, and so we were able to respond to that. So then, anyway, so we had, everybody was trying to digest Sarbanes-Oxley, and there's some issues. Jeff mentioned the clawback provision. That was sort of a underlying thing, and only recently really has the SEC sort of stepped out with respect to this clawback provision, most notably in a case called CSK Auto, where they went after the chairman of a public company where there had to be a restatement due to auditing problems at the company, and the SEC admits that the CEO didn't know anything about what had happened with respect to the underlying problems. It was really the CFO that had been doing some things that he shouldn't have been doing. But never mind that. The SEC is suing to claw back the bonuses that the CEO got, notwithstanding his lack of scienter. And so that's one issue that's left over from Sarbanes-Oxley, and that Dodd-Frank has actually made more stringent. So, which brings me to Dodd-Frank. So, Dodd-Frank takes a completely different view of the division between the federal and the state views of corporate governance, and basically intervenes in a much more heavy-handed way, among which is the clawback provision, which has gotten strengthened. Now it's not even, now there's definitely no requirement for knowledge, and it has to do with any sort of restatement, not just necessarily one connected with fraud. Say on pay now is a federal position that's written into the statute. And they've also, Dodd-Frank has ended, this is not necessarily corporate governance, but they've ended some old preemption language, sort of in the opposite vein, now going back and giving more authority to the states with respect to some aspects of consumer banking law and whatnot. So it's sort of a mixed bag on both of the federal government's relation with the states. But one of the most significant ones, which Jeff also mentioned, is shareholder access, which Brandon's going to talk about a little bit more. But shareholder access to proxy card is, I don't know how many of y'all are aware of this issue, but basically it says that not all shareholders, but some shareholders may be able to nominate directly people for the board of a public company if they meet certain eligibility criteria. The SEC just adopted a rule in August to put into effect this permissive authority that they got through Dodd-Frank. And that's being sued now, being challenged by the Business Roundtable and by the U.S. Chamber of Commerce, and the SEC has stayed that provision, so it's not going to be in effect for this year. And so we'll see how that litigation turns out, but basically they're suing on Administrative Procedure Act grounds that there was not a appropriate analysis, cost benefit, and all of that taken into account. So this shareholder access provision, basically, notwithstanding that North Dakota and Delaware had both adopted different provisions with respect to shareholder access, this one now that the SEC has adopted, empowered by Dodd-Frank, basically views as a federal right of shareholders the ability to nominate people to be directors of a company, but of course only for some. They have in a very cynical, I'd say, way that they don't really even defend very well in their discussion of the rule. They chose 3% and 3 years. 3% meaning you can have certain shareholders band together. If they make up 3%, they can nominate a director directly if they've all held their shares for 3 years. Now, why did they sort of pick this number out of the air? Well, it's because basically a lot of folks from the, I'll call them the activist shareholder area, who were not really happy with Chris Cox's proposal of a few years ago for 5% as being the number of folks being able to get together to nominate directors. They viewed that as being unattainable in reality, so they fell back. 3% after heavy lobbying behind the scenes was the one that the commission basically landed on, because they wanted to keep hedge funds out but allow some other more favored groups like union groups and other state pension funds and whatnot to be able to have this right. So, you know, ultimately, what this sets up is basically a very adversarial relationship between a board of directors and the shareholders, or at least some shareholder groups. The SEC is trying now, through this rule, to insert itself in the middle, saying that you know, we have to be notified if a company finds something wrong with the proposed nominees that these shareholders are putting forward, and then sets up a process of no action letters to try to sort that out. But I think what's going to happen ultimately is that there's going to be a lot more litigation and distraction for companies, because inherently there must have been, you know, if you think about how this will play out, you have shareholder groups who might propose nominees, and the board's nominating committee will not take those nominees, so the shareholders will go forward with their nominees. So the board has already asserted its fiduciary duty and decided that you know, those particular nominees are not as good as the ones that they're putting up. So there will be, I think, an inherent litigation that's going to come out of all of this, and so I think people will probably bypass whatever no action process is set up. So unfortunately, it's going to mean a lot more cost for shareholders ultimately, and a lot more distraction for boards and corporate management. So ultimately, what all this comes down to, and my time, I think, is about up. But basically, it comes down to, you know, how do we view the relationship between the board of directors and the shareholders? You know, is the board a group unto itself, not really owing fiduciary duties to the shareholders, a self-perpetuating type of thing? And, you know, do we have to set up through a federal mechanism a type of system for shareholders to bypass that? And is, you know, state law and the rights of under state law, which basically views all shareholders being equal, you know, do we have to bypass that and now make some shareholders more equal than others? So anyway, I'm sure we'll have more discussion with that, but we'll end on that note.
Brandon, I have a sense you might have something to say about all that.
And I feel, I'm Brandon Rees, AFL-CIO. We're the largest federation of trade unions, and I do feel something like a Christian that's been invited to the Roman Colosseum to be fed to the lions, and I am honored to be seated next to perhaps the leading intellectual lion, Paul Atkins. So, perhaps it's not a surprise to you that my views on Dodd-Frank. In fact, I reject the very title of this panel, that Dodd-Frank is a creeping federalization of corporate governance. I don't see it that way at all, and I would like to spend my time talking about why that is. First, just to briefly address the changes in Dodd-Frank that Jeff outlined and why they're do not represent a creeping federalization. First, Dodd-Frank requires disclosure of companies' board leadership structure and whether they have an independent chairman or combined CEO and chair. It also has certain executive compensation disclosure requirements within it. Well, we already have those requirements under the existing SEC regulations, and I didn't see really many significant change in terms of an increased mandate on companies in that area. Likewise with compensation committees. Dodd-Frank requires that compensation committees be consist entirely of independent directors. Well, again, we already have that under existing SEC regulations when the SEC approved the stock exchange listing standards that require that all publicly traded companies on an exchange have an independent compensation committee. And then lastly, the say-on-pay vote, requiring companies to have an advisory vote on executive compensation every 1, 2, or 3 years. That was within Dodd-Frank. Well, first of all, it is an advisory vote. And secondly, shareholders under existing regulations and stock exchange listing rules already vote on pay packages, binding votes on equity compensation plans and binding votes to approve performance-based compensation plans for executives. So I just don't see that the notion that say-on-pay somehow represents a federalization. If anything, it seems to be a very modest tweak to the existing SEC requirements for public companies to solicit their views of their shareholders. But the most hotly debated issue, and that Paul also talked a lot about, was this question of equal access to the proxy and allowing shareholders to nominate directors to be included on the proxy card of companies' ballots. Again, I don't see that as being a issue of federalization of director elections. The election of directors is a fundamental state law right of shareholders. That is true. But proxy access is about the regulation of proxy solicitations and is not a question of state corporate law. And in fact, under the proxy access regulation, shareholders have to be able to nominate directors, and those nominees have to be qualified under state law for them to appear within the company's ballot. For 75 years since the passage of the 1934 Securities and Exchange Act, we've had SEC regulation and federalization of the proxy solicitation rules, and that was to address to problems and practices that were common before the 1934 Act in proxy voting by shareholders. For example, shareholders would vote. They weren't told who they were voting for. They were just asked to vote for the board's nominations, which would be determined later. In other cases, proxy votes were cast when you endorsed your dividend check, that was authorizing the board to vote on your behalf. So it was those types of abuses that led to the federal rules regarding proxy solicitations. Even the inclusion of shareholder content within proxies and on corporate ballots is not a new issue. We've had the shareholder proposal rule, Rule 14A8, that's been around since the 1940s and is not a new area. But needless to say, this was the issue that many critics of Dodd-Frank seized on and advocated the alternative that either states should determine whether shareholders can include should have the right to include their nominees on the company ballot, or should there be a private ordering of individual companies deciding who to include? The problem with that approach is that it rejects 75 years of securities regulation in this country of having mandatory minimum proxy solicitation rules. And secondly, it wouldn't work because more than half of all publicly traded companies today limit the ability for shareholders to change the bylaws of the company to create things like proxy access that would be permitted under Delaware's corporate law. And so I think if you didn't have a minimum standard for proxy access, the reality of what you would have is that companies that have good corporate governance, that are responsive to their shareholders, those would be the companies that would have proxy access processes put into place. And it does those companies where shareholders' desires were being ignored, where you had the most entrenched boards of directors, those would be the companies that would successfully resist proxy access, and so you wouldn't have any potential gain from it. And then lastly, just on the question of proxy access, I disagree with Paul, not surprisingly, but I think it really was an evolutionary change, not some radical or revolutionary change to the proxy solicitation and the director nomination process. In fact, it's very conservative. 3%, you have to be a 3% shareholder or group of shareholders for over 3 years, which certainly no union pension plan. In fact, I would suggest that if you combine every single union-sponsored pension plan, that they would not own more than 3% of any individual company. That in fact, if you look at many boards of directors, those that under the current rules nominate 95% of all directors that are put forward for election, very few boards of directors, including the CEO, own a combined 3% shares of their companies. So to say that the share owners that own 3% of the company should not be allowed to use the proxy mechanism to put forward a director candidate just doesn't seem to be a level playing field. Given the concerns that we've had over the past decade regarding directors doing their jobs and the unfortunate performance of the capital markets and the fact the stock market has gone nowhere in the past 10 years, I think it's a change that was both sorely needed and that we will have at the end of the day.
Thanks a lot.
I thank you for applauding out of politeness.
Well, guys, do we have anything left to talk about? Seriously, let's start out with a question or two about the subject that you two just most recently focused on, namely proxy access. One of the questions that you touched on was necessary to an evaluation of what the extent to which proxy access in Section 971 of Dodd-Frank represented a change, represented an increased role for the federal government over what was there before. And I think that very much depends on your view, as Brandon suggests, of whether or not the 34 Act, Section 14A in particular, provided sufficient authority to the Commission to do what it did even without Dodd-Frank. I don't think it's controversial to say that that's a debatable point. Brandon, you've mentioned your sense about roughly about why why the Dodd-Frank provision really wasn't necessary. But I wonder, Paul or anybody else, whether you have a view on that before we turn to a little bit more about the substantive impact of proxy access.
Well, yeah, I mean, just to throw it out here, I mean, I think it's clear that people who are advocating shareholder access were nervous enough in the wake of the Business Roundtable versus SEC decision of the D.C. Circuit back in 1990, which basically drew a line and said, I mean, to Brandon's point here about, what the SEC has under this prior regime will have the power to do, it it could deal with proxies from a procedural aspect versus proxies solicitation from a substantive legal aspect. So as long as SEC would deal with procedure and, how many shares you have to own and, what the whole thing of submission, number of days and review and types of things that were permissible to be brought up, then that was okay. But if it gave a substantive right to shareholders, then that was treading on state law. So that was why Dodd-Frank had that permission built into the statute in order to take that issue off the table, which I guess it is, unless somebody can figure out a way to attack that. But I think overall, you have to look at why is this being pushed so much, and I think a lot of it has to do with it's not necessarily that people will put forward nominees or want to spend the money to run them or anything like that. We had a roundtable in 2007, and I got two I'll call them institutional representatives on that roundtable, basically to admit that they use these sorts of rights to as leverage against management of a corporation to get some of their private goals advanced. And you have to remember that one shareholder, unless he's a controlling shareholder, really doesn't owe any duties to anyone else, and shareholders are not monolithic. So to view shareholders as a group and that some small 3% group or whatever can represent everybody else, I think is reading too much into it. So I think that was the real the test here of Dodd-Frank and how it did traipse into over the line was by giving this authority that they viewed as being questionable out of the 3400.
Let me get Sarah and Jeff involved on a slightly different point, and that is perhaps responding or getting your sense of what the practical impact of the proxy access rule is likely to be. We've heard Paul's suggestion that it's likely to create an adversarial atmosphere and increase costs. Sarah and Jeff, is that something you care to comment on?
First, I'll take the low-hanging fruit, then you can do the obscure points. I think nobody knows for sure, but it is without doubt that there are a number of things occurring at the same time, of which proxy access is one, which are significantly, if slowly, changing the balance of power between shareholders and boards of directors. It has nothing to do with creeping federalism, but we seem to have crept away from that topic anyway. And they are collectively significant. Some of them are legal, like proxy access. Some of them are questions of habit. For example, active shareholders, companies like to call them activists to be pejorative. I think just active, for some reason, tend to express most of their activity with shareholder proposals, which are non-binding and have very little effect, whereas if they did exactly the same thing by calling up the company and saying, we're going to withhold votes from your directors if you don't do X, the impact would be huge. Doesn't take a law change, it's just a habit question. Don't know why it's not changing. If that changes, it will be a big deal. The trend of majority voting is probably way more important than access, but the bottom line for all these things, after I add a couple more, is that they can be combined, and that people haven't yet begun to do that because they haven't figured out how to do it well. But access will be significant when combined with others. The additional examples, so majority voting is very, very important because it's much easier to get people to agree on directors they do not like than it is to get them to agree on directors they do like and to run a slate. And 50% is a very, very attainable number given current vote totals. Given the broker vote, for example, took away 10% of our vote. That's, it varies by how heavily retail held you are, but and the background radiation is going up, which is, background radiation is my term for the idiosyncratic proxy voting guidelines that various shareholders have, so that, say, there's a British pension fund which votes against all male directors if there's no female on the board. They may be the only pension fund to do it, but pension fund B may have a different issue, and collectively that background radiation is meaning that the no vote against directors has gone up from around 0.5% to 2 or 3%. add on 10 to 30% for the broker vote, depending on the company. Ours was 10%. Add on if there is ever a shift in habit with activist shareholders targeting boards rather than proposals. You then throw in public-private partnerships, which is, I think, how proxy access will be used, of which the Occidental example is the most prime. You have a relational investors, which is expert at running proxy fights. CalSTRS, which is not expert at running proxy fights, but is expert at holding large amounts of shares. And they partner up. That is a way that activism can be used, and indeed the main beneficiaries of activism of proxy access may not be the hedge funds or the CalSTRS, but the active investors we tend not to talk about, the Nelson Peltzes, the relational investors, the ones who have the operational budget to use something like this. Last but not least, often not focused on, but it should be, remembering that all these things can be combined, and they simply aren't yet, is that share lending, which is a misnomer, it is actually not a borrowing of shares, it is a sale and then a sale back, legally and must, I don't see any way around this, must transfer the voting rights if you borrow the shares on the record date. Now, that's the law. There are all sorts of qualifications, but the fact is it can be done. So whenever someone tells you, well, the brokers have to have Reg T, just forget it, it can be done. It has not been an interesting right before, because on the record date, at most companies, the only thing you know that's going to be up for a vote is the directors. And as long as you have a plurality system, as long as each director votes for him or herself, they get elected. So why would you borrow shares when they have one vote and they win? But with the majority of large companies now having majority voting, so 50% of the votes withheld, they have to offer their resignation. Suddenly, borrowing shares on the record date becomes an interesting proposition. Not just an interesting proposition, but probably the cheapest power in all of America. I probably shouldn't say this with Brandon here, but luckily the oil industry has so few employees, labor tends not to care about us. We just have machinery and leases. You can borrow 10% of Apache's shares on the record date for $34,000. You can buy 10% of the vote of an S&P 200 company for $34,000. Show me cheaper power in America. So these things which are currently not being combined well and are not being thought out well, will be thought out well, will be begun to be combined, like that book Outliers that has the chapter about how it takes 10,000 hours before you're good at something. Activists have 10,000 hours under their belt on shareholder proposals. They missed the boat on that one. If they start use some of these other techniques, absolutely access will matter. We have shareholders in our top 50, not in our top 10, but in our top 50, who have 100 companies in which they have held 3% for 3 years. And when I ask them what they're going to do with it, their answer is, we realize it's power. It's just kind of hitting us. Don't know what we're going to do with it yet, but we'll figure something out. So there's going to be a learning curve. Well, I mean, if you've got power and you're a money manager, you should think about what to do with it. And Warren Buffett tends to not just buy the shares, but sit on the board. So if you're going to bet on the horses, you might want to train them too, which is what governance is. So I think that proxy access will not be used the way many companies have portrayed that it will be used in the early years, at least, which is that Brandon will call CalSTRS and run a slate of directors somewhere, because CalSTRS on its own doesn't typically own enough. But that it will be used, and it will be significant power when combined with some of these other changes to laws, regulations, and habits, and collectively they will shift the balance of power from boards to shareholders, which is a trend that's been going on for the last 25 years anyway, which has at least as interesting a debate as the question of creeping federalism.
Thanks, Sarah. Jeff, do you have anything you want to add to that?
Sure. Just long term, it's hard to predict, and Sarah knows a lot more about these issues than I do. So long term, I can't say. With respect to our members, short term, it's going to be a last resort tool for a number of reasons. One that Brandon mentioned, we ran the numbers on this, and if you take the 10 largest public pension plans in the country, they're generally not going to have 3% of the shares of a company. So they're going to have to team up with other people in some way, and that's going to be somewhat difficult to do, in part because of the 3-year requirement. A lot of the people they might be able to team up with are not going to be available because of that requirement. So I think I can't speak to the long term, but short term, at least within our membership, this is going to be a last resort tool. And I can tell you, within our membership themselves, within our membership, some are concerned that the 3%, 3 years is too high, and that our members will never be able to get together to use this. So even within our own community, there's some concern about our ability to use this tool, so only time will tell about whether our members will be able to use this and how easily they'll be able to use it.
It's very ironic for me to tell Jeff that he needs to be more optimistic about the power that's just been handed to them, but it is already the case that the negotiating power of the Nelson Peltz funds has totally changed because of access. They can go in and say to a company, and the way Peltz does it, it varies by which, whether you're talking about Ackman or Relational or Carl Icahn, but they outline what they want to a company and outline the board seats they want, and they get a cave-in much faster because they can outline what it takes to, how easy it will be for them to marshal the shares. The other thing that is going on, which is not measurable, which I'm sure Jeff knows about, but he's probably pretending he doesn't, is that the very large shareholders who do regularly own more than 3% are now quietly calling the more active shareholders and saying something like, do you have a problem with Occidental? Which is basically a way of saying, our votes are there if you go after them. It's not actually any kind of legal partnership, but it's a signaling. So Fidelity could do that without actually being active, but it's a signal to the act that there are votes there to follow up. And remember, with the 3%, that's what you need to hold to put up the directors. You can borrow the shares to vote them in. So, yes, short term there have been some excessive wringing of hands, but there are a lot of moving parts here that make this very interesting space.
Sarah, what's your guess for, let's say, 2014? How many proxy access challenges do you think will occur?
It depends on how smart the active shareholders are with this power. I just outlined some of the things that can be done. Some of them mystify me that they are not. I think the only variables that corporations control is how many idiotic decisions do we make, because what really has to happen is you need 2 or 3, and not Enron-like companies, but essentially a company that's lost money for 5 years, bottom of their peer group, CEO's the highest paid in the industry, and it's got the mistress on the payroll. That's just screaming for an access slate. And once an access slate or a majority vote, just vote no campaign works at an S&P 100 company, the negotiating power of every shareholder around skyrockets. Because every single director in corporate America will say, whoa, it happened at Target, it can happen here. The biggest thing that Occidental has done is it sent a signal around the world, and believe me, this has been talked about nonstop in the corporate world, is even a company with incredibly good performance can have active shareholders step in and ask that the CEO retire, the chairman, and he's going to retire. So, the key there was Occidental, unlike some companies, has had terrific performance. So that was not lost. So I think the variable that we contribute is how many easy targets are created. The other variables are really in the shareholders' hands, and it's interesting to watch. So it will depend. Are you going to switch from shareholder proposals to director-based voting? Are you going to target majority vote companies? Are you going to, my understanding is the council's looking at small companies. You don't get any headlines from those. What are you thinking?
Sarah, I could spend quite a while talking about proxy access, and I'm sure we all could, and devote a whole session to it and more, but I think I can safely say that if you look at the bulk of the Dodd-Frank corporate governance provisions, most of them you'll find in the area of executive compensation. The compensation committee and compensation consultant standards that it prescribes, and the say-on pay votes and say-on frequency votes and say-on parachute votes and things like that. And I want to turn to those because obviously the executive compensation history was, I think, in the same way that the demise of the Enron pension fund was the political lightning rod for Sarbanes-Oxley, executive compensation was and the financial crisis were the lightning rod for Dodd-Frank. And I'd like to get your views about what happened or what's likely to happen with those executive compensation provisions. And Sarah, I appreciate your admonition that we ought to stick to the creep topic at least a little bit. So I'd like to start off with seeing what you folks think about how say on pay is going to relate to state law, state corporate law. Obviously, there were initiatives before Dodd-Frank to encourage companies to institute say-on-pay practices, shareholder advisory votes, even without the legislative mandate. And it's correct, as Brandon says, that before Dodd-Frank, companies routinely, and for good reasons, tax, if not perhaps being one of them, submitted pay plans, incentive equity plans to shareholder votes, binding votes, as you point out. But as far as I know, there was no legal mandate to do what Dodd-Frank now requires, which is to have an annual or semi-annual or triannual, depending, advisory vote by shareholders. And this is, I think, a significant step. I don't think anybody would deny that. The question is, what's the impact on state law? Does it create in some ways an additional role for state law? How's it all going to play out? Is state law something that had much of a role to play before that? So who wants to start on that one? Anybody?
I think you ought to, Larry. You're the Delaware lawyer. Put your Delaware lawyer hat on.
The opinions
Talk
I
about
expressed-
director qualification bylaws. There's an interesting thing there, so go for it. Just, step away from the commission for a minute.
No. I'm here and I'm fully employed, but I'm here to ask questions.
I
So,
see.
what's the relation to state law? I mean, was there ever, and is there still a role for state law to play in regard to executive compensation matters? What's the role for the board in private ordering?
Well, I think, one issue of all of this is sort of the scattershot, and as you sort of allude in your question, the scattershot approach of the federal government to some of these questions without necessarily a well thought out plan. And when you remember the list that Jeff went down that was in Dodd-Frank, I mean, there's no real consistent theme. It's just sort of whatever happened politically during that time, then Congress glommed onto that to stick it in. And most of the ones, as Jeff was pointing out, already had regulatory aspects to them where the SEC or others, DOL or whoever, had taken steps through the years to have requirements. And so Congress now is just either, formally ensconcing them in statute, so, chiseling them into stone, so they're going to be hard to change in the future, or, they're just superfluous sorts of rules. So I think the real question is, how are these things going to be interpreted in the future so that if the SEC or other federal government agencies start to implement them with rules and other things, how will that then perhaps preempt what states otherwise might want to do? And then your question as to private ordering, I think, is really key, and that going back to the whole issue with shareholder access, where the SEC basically has said there shall be no private ordering. What we view as, out of our, arbitrary and capricious choosing of whatever standard that we've done, this is what people will have to live with. They can add to it, but they cannot take away with it, despite what the whole, individual aspects of a corporation might be.
Brandon, can I
Yes.
get you into this fight?
I disagree with Paul completely. That's in summary. Now, to elaborate, Dodd-Frank addressed executive compensation appropriately so because given the context of what we've just gone through, the worst financial crisis since the Great Depression, stock market returns, the worst returns between 2000 and 2010 since the Great Depression. Yet, at the same time, CEO pay has never been higher in the United States. Going from an average of 40 times the average worker's pay after World War II to the 1980s, to 100 times in 1990, to over 500 times by the end of 2000, and now is around 300 times for an S&P 500 company. So you had a phenomenon where CEOs have never been paid higher. yet that stock market returns have never done so worse. Now, why does executive compensation matter? Well, it's the incentive structure that guides executive decision making, and the concern that the public and Congress and our political process has decided is that executive compensation incentivized excessive risk-taking, particularly within our financial institutions. That led to an economic crisis that has not been unparalleled since 1929. That's what we faced, and that's why say on pay is an appropriate measure, but it's also a very limited measure. It's a feedback mechanism from shareholders to boards of directors. How are you doing on executive compensation? And I strongly believe that the success of our capital markets since the Great Depression has been based in part because we do have minimum standards for corporate governance in this country. And in terms of private ordering, Dodd-Frank does have private ordering for say on pay. Companies and their shareholders, more importantly, can choose whether they think 1, 2, or 3 year votes are appropriate. And certainly companies can and shareholders can go beyond that in terms of more effective tools if they're able to come up with it. But we do have to have minimum standards in this country if we're to protect shareholder value.
One quick retort to there, sorry, I want to bring this up. I think part of the problem is in Washington is there's a gulf in perception as to what actually caused the financial crisis, whether it was, excessive compensation or the compensation structures at firms, or, as I believe is a lot of regulatory failures over the years, not deregulation, but actually regulation that was skewed, including government housing policy, Fannie Mae, Freddie Mac. Those were, I think, the chief things. And if you look at Bear Stearns and Lehman Brothers and AIG and those sorts of things over the years, I dare say that the shareholders were whining and crying during the times when the stock price was soaring during those years over the risk-taking that was going on there. I think the real problem was, again, and this goes back to regulatory failures, is the lack of transparency of the balance sheets of those particular types of institutions, a lot of which is caused by the very regulation of safety and soundness of the banking regulators and the oversight at the SEC. So I think if the government would pay more attention to allowing the marketplace to peer into these sorts of types of firms to then have that be reflected in the stock price, I think that would have a lot more effect on the firms rather than trying to rely on this Rube Goldberg type of system of hanging your hat on an adversarial relationship between different blocks of shareholders, or trying to make the boardroom into a management structure that it's not really cut out to be.
I actually think the compensation provisions in Dodd-Frank encapsulate pretty well some of the discussion of state versus federal and which is better from a content point of view. I think that many of them are sloppy. They are inelegant. When you go talk to people on both sides of the aisle, they would say, well, we're doing this because it essentially is what it resonates, it gets us headlines. We haven't kind of thought it out as well. I raised on Capitol Hill, why aren't you mandating a vote on board pay? The shareholders elect the board picks the CEO, and certainly nobody should be voting on the pay of the people below the CEO. Now, the fact is, once it's federal law, it should be annual. And Apache's board yesterday voted to make say on pay an annual occurrence. And as a referendum on how the company is doing, essentially a thumbs up, Mayor Koch kind of thing, I think that's a good thing. But I think substantively it is a very sloppy thing to suggest shareholders have any way of knowing whether the pay level between our number 3 and number 4 executive is set well. And there was a missing step there on the board pay. Similarly, a lot of the disclosure provisions are, I think, not going to generate very much useful information for shareholders compared to the words that get put in. Majority voting, which is powerful and elegant and simple, was dropped, and some kind of wordy disclosure things were left in, which I think is not accidental for the federal government system. And if you compare that to Delaware law, which I'm not universally a fan of, but there is, in fact, a lot more, in general, expertise and care, especially in the case law system. So some of the sloppiness that you see when the federal government is involved, and I don't have a strong opinion about whether states or federal government is better, but the sloppiness, is there. You can point to it, and it is not helpful, and it does have costs. So I think that is an area where you can have an interesting state and federal discussion, because Dodd-Frank creates some examples.
Jeff, let me ask you for a comment on this. In terms of the efficacy of the say-on-pay vote, whatever the causes of the financial crisis and whatever role executive compensation played in that respect, there's still a separate question of whether or not the shareholder advisory vote is a useful tool in dealing with whatever problem was there. And there was an interesting study that came out sometime in the last month or so from a proxy advisory firm in the UK called Pensions and Investments Research Consultants. And the gist of it, if I read it right, was that the say-on-pay requirement, which has been in the UK for 6 years or 7 years or so, has been a useful tool in encouraging engagement between shareholders and the board. And so a lot of it sort of trumpets that positive result. And then they look at the numbers and find that it really didn't seem to have any impact on the growth of executive compensation. So the question is, what's the say-on-pay vote really likely to accomplish? And a lot of that may have to do with how it's addressed in the dialogue between shareholders and the boards. And Jeff, I don't know if you have any thoughts about how that's likely to play out, but if you do, I'd love to hear them.
Well, I'd just say as far as the amount of pay, I mean, that's not the objective. The objective is to improve the linkage between pay and long-term corporate performance. And as you mentioned, there is a large body of evidence about the UK application, which concludes that say-on-pay in the UK has improved that linkage between performance and pay. And most believe it has resulted in UK companies adopting better pay practices. And it's not just in the UK, it's in many other countries around the world: Australia, France, Germany, India, Italy, Poland, Switzerland, Taiwan. They've all adopted it as well, and they seem to think, at least those I've talked to, that it seems to be working pretty well there. I mean, the bottom line purpose of it is to enhance the level of communication regarding a very important element of good corporate governance.
We have plenty more to talk about from the prepared text, so to speak, but I want to make sure we have enough time to respond to questions from people in the audience. And if there are questions, go right ahead, raise your hand, and speak up, because my hearing's disappearing.
I had a question for Sarah and Jeffrey, but before I ask the question, Sarah, if you could clarify something. You said one could borrow a large amount of stock in the company for relatively little out-of-pocket cost, but it is required to put up 100% cash collateral for the borrowed shares.
Yes, but you can borrow them for 24 hours. All you have to do is borrow it on the record date.
Or you still need to get the cash collateral together.
Sure, but the point is, it is vastly cheaper to borrow the shares for one day to acquire the vote than it is to buy the shares to get the vote.
Let me ask you the question on my mind. And this has been mentioned in the past. It seems that companies are criticizing these days the methods by which investor groups make their voting decisions, in part relies on proxy advisors. Proxy advisors are defending fiercely the value service they render. But it also seems that the investor groups are criticizing, with a lot more success, the reliance of companies on broker votes. Now, am I mixing apples and oranges, or is there, or just politics?
It's just a whole lot of muddled thinking and people making stupid arguments when there are good arguments to be made. So you got it exactly right. It is a normal thing for pension funds, including companies' own pension funds, to outsource the buying and selling of the shares. You hire Fidelity or something, and that includes the voting of the shares, or it's normal for the entities you hire to outsource the voting. So the fact that you hire expertise to use the proxy vote is not an interesting fact. We hire lawyers, we hire consultants, and so the notion that we would somehow have regulations that say you can't get help with a proxy vote, and therefore that somehow proxy advisory firms are a bad thing, I think if that's the premise of your argument, it's really quite silly. There are certainly issues you can raise about the proxy plumbing generally, which basically means the entire set of issues that are raised by getting a proxy from the company out to the shareholder and back and having it voted. There are a large collection of them. Some of them are very serious. And a couple of them relate to proxy advisory firms. There are a couple conflict of interest issues there that are worth raising. There are a couple appeals issues. A couple of the proxy advisory firms do not announce in advance how they're going to recommend the vote, and in rare cases, I think it's overstated, but in rare cases, that's based on factually false data, which can affect a lot of votes. But they're relatively small. So, I think the proxy advisory vote issues, they are there. They should be addressed. They shouldn't keep you up at night. Just shouldn't. I think the broker vote issue is largely one it's now in the past. The idea that if you didn't vote your shares, someone else would vote them for you. I get the notion that your broker had the expertise, but in many cases it was not individual owners actually thinking it out. So that is also uninteresting. What is interesting that is related to that is what's referred to as client-directed voting, which is one where there is also a lot of muddle-headed thinking because it's basically political finger-pointing. You have activist shareholders who like an IS or Riskmetrics having the ability to get other people's proxy votes and cast them, saying that an individual investor can't do the same thing, can't say, but I want to give my instructions and have someone else follow them. It's more complicated than that, but there's a lot of finger pointing when there doesn't need to be. And what really has to happen is grown-ups have to sit down and say, how can we make sure that people with a net long economic stake in the company vote the shares with the relevant information? And that isn't happening now the way it should, and that should happen because we have real competition now that we didn't before. So these are serious questions, and I think there are people here who are trying to work on getting the right answers. But yeah, most of what you read in those subjects is a bunch of garbage.
I just want to add that all of those questions and more were put on the table in the Commission's concept release from this summer about proxy mechanics, or as most people call it, proxy plumbing. And it's fascinating to observe the debate surrounding all that and how those issues do interrelate, and what kind of system do we want in terms of voting? How much do we care about informed voting? How much do we care about delegation? The story has going to unfold for a while, but it's good to see, at least as far as I'm concerned, that the issues have been put out there, and there are a lot of interesting comments that have come up on the subject.
They're important issues.
But we have a line of questions back there, and I want to get to those, so go right ahead, sir.
Thank you. I just wanted to kind of go back more generally to the topic of creeping federalism, and at the risk of offending some of y'all, I remain unconvinced that this is a positive thing to have the SEC expanding its regulation. I would like to hear what you have to say about it, but I would, before I do that, I'd like to say that, it seems to me the sole purpose of regulation, at least of the securities market, would be increasing investor confidence. And you have an unintended consequence of that, which is that it increases also transaction costs. Well, at least in my mind, the SEC is kind of like the fire department that never got to a building before it was completely burned down. We've had Enron, WorldCom, Bernie Madoff, and the more recent issues that we faced in the last couple of years. So I guess what I wonder is how can an entity that has so consistently failed increase investor confidence, and isn't it by creating more regulations just giving us more unintended consequences of increased transaction costs instead of also getting the benefit?
Fair enough. I'm not sure there's anybody in the panel who wants to answer that before I tried, but if there is, that would be great.
I would submit that the recent stock market rally from the February, March 2009 nadir following the financial crisis shows that there is investor confidence in the ability of regulators to respond to these type of crises. I think that we averted the Great Depression in this country, and it took over a decade to recover from the 1929 stock market crash for investors to return to where they were before that, and we've done that in less than 2 years. I think that's a sign that there is confidence, and we have learned something to have smart regulations, and I think that Dodd-Frank falls into that category. It didn't expand or federalize new areas of the securities law, in my view, as I argued, and is relatively modest, made relatively modest, but important and significant changes to how corporate governance operates.
I think you make a number of good points. I think there are probably some qualifiers. I think Brandon had indicated not that there wasn't creep, but just that the creep had started a long time ago. Because many of the examples you gave were simply that in prior years these
right,
areas...
we federalized it in 1934. I submit that was a federalization.
It's been federalized for a long time, not so Dodd-Frank didn't start it, this ball rolling. And certainly there are things the Commission does that one cannot be proud of, but I think in fairness, the Commission has historically, and it certainly has better and worse years, been one of the jewels in the federal government's crown, which may not be saying a lot when you look at some of the cabinet departments, but it certainly has attracted unusual talent, and there are an awful lot of very serious practitioners who would say to you that the state securities regulators tend not to have as much budget and tend not to, in fact, be as effective as the SEC. So while the Commission may not be all that as effective as we would like, it may, in fact, have had somewhat more successes than state administrators, but it is an absolutely fair point, and I go back to the point I made in the previous question that certainly Dodd-Frank does give some examples of when Congress weighs in, there is some sloppiness that at least in some states you are somewhat less apt to see, and that's just because it's an entire national system and it doesn't have the bandwidth that some of the states do. So legitimate points, but I think not quite as dire as you suggest. And I've lobbied the Commission for 30 years, and I come away thinking some of the best people I've ever met are there. So,
well, just to throw one quick point in, I wouldn't ascribe the run-up in the market since '09 to any great confidence in Dodd-Frank or necessarily even in my alma mater there at the SEC. I think the SEC, you're right. I mean, Richard Breeden used to say that the Enforcement Division used to ride down out of the hills and shoot the wounded because it didn't want to really dirty its hands in real investigations. With Madoff, one of the people in the New York office who basically didn't listen to Marco Polis told one of my staff members that the heads of the Enforcement Division actively discouraged the staff from looking after Ponzi schemes because they did not bring the desired headlines in the newspaper, because you save Grandma Jones $10,000 versus you bring a $500 million fine against Goldman Sachs. That, even though it's a dumb type of case to bring, that's the thing that goes to your resume and makes people eager to hire you later. And then one other little story. In 2007, I was up in New York, got a presentation with Kathy Casey. Actually, we were at a investment bank, and the head of the credit derivatives group of this one investment bank had a very simple slide, 3 slides, showing how CDOs had really spiked since 2003. And I thought, oh my goodness, I went back to the folks in Market Reg to ask about that, and they said, don't worry, we know that's happening, but they're all AAA rated, so it doesn't really matter. So the trouble is, a lot, and that's a regulatory problem. I can go into that at length another time, but a lot of these things are caused by, unintended consequences of, what are supposedly with rating agencies in 1975, the net capital rule, for example, but over the years, they get ossified and nobody really trusts the market itself through transparency. And I think that's, again, a theme that I think is really constant here, rather than trusting our, going into, corporate governance or whatever kind of artificial constructs there are, we should trust the marketplace more through transparency. I think that would get a lot more bang for our bucks, but anyway.
I just have
I want to keep moving with some questions, so if you, Jeff, I'm sorry.
Oh, I'm sorry. Just 2 quick points. First, on the sloppiness, I agree with you, Sarah. I had some beautifully written language on all of those areas, which unfortunately got changed along the way. Some of which was introduced, but got watered down, as you know how that happens. Second, on the SEC, my prior job, fortunately or unfortunately, I got to spend a lot of time going around town talking to the various regulators. And I have to tell you, from an investor perspective, one, the SEC is the only one in town that actually has investor protection as part of its mission. But two, after meeting most of the other regulators in town, I always thought that if you're going to spend money paying someone at the SEC or spend money paying someone at one of the other regulators without naming any, that American taxpayer gets much more, at least from an investor perspective, much more bang for their buck sending that money over to the SEC.
Thanks. Yes, sir.
J.W. Verrett from George Mason Law School. My question relates specifically to the issue of proxy access, but also what that dynamic teaches us more broadly about federal preemption of corporation law. So specifically with proxy access, it seems to me there's a space that remains open for boards to maneuver against proxy access, and here I'll make a shameless plug for my new paper, Defending Against Proxy Access, Delaware's Future, Reviewing Board Defenses in the Era of Dodd-Frank in the Journal of Corporation Law next month, where I designed 16 defenses boards can use to defend against proxy access, most of which are still legal under the Delaware Code, some of which would require amendment to the code but are nevertheless worth considering. For example, director qualification bylaws that Sarah mentioned. I have some ideas about how to design those. Denying indemnification or D&O coverage to insurgent nominees, which I think is perfectly permitted by existing precedent in Delaware law. More committee delegation of decisions to committees that exclude insurgents. So I think one of the things that we can see about the Delaware Code as opposed to federal law is very constrictive by its very nature, by its very design. The Delaware Code, I think you can accurately describe as flexible and enabling. So in some ways it seems to me that if at least some of my defenses will work, and some people seem to be talking about implementing them, at least once the litigation gets finished, it seems to me it's sort of like Delaware's like Ali, right? He goes against Foreman. Foreman's stocky, and Foreman's not very flexible. So he lets Foreman beat up on him as much as he can, and then he rope-a-dopes and takes Foreman down. It seems to me that's the history of Delaware over the last 60 years since Bill Carey started first sort of Foreman punches. So do you agree with that? Do you disagree with that? How much space is there left open for the code to adapt, the state code to adapt to the preemptive measures in Dodd-Frank? And sort of a second compound to that, SEC certification to the Delaware Supreme Court. This seems like the sort of issue, a lot of stuff in the proxy access rule seems like the sort of thing you could certify too. Will the commission certify though? Will it certify, and if not, how can we make it certify questions to state law?
I think I can actually speak to some of that, JW. And I've never heard of that article. What? Just kidding. As was mentioned before, the proxy access rule has sort of as a foundational or theoretical underpinning the existence of state law rights to nominate. That is, if there is no state law right to nominate, that's the state law space that the access rule doesn't intrude on and doesn't create nomination rights where they don't exist. So there's one interesting aspect of the proxy access rule that pretty clearly dovetails with some of the stuff you've written about, namely the question of whether or not bylaw provisions under state law can limit the right to nominate and thereby indirectly limit the right to use the access rule. And the answer is, to some extent, yes. The staff has made it clear in some recent pronouncements, as has Commissioner Walter, that given the premise of proxy access, if a state law bylaw denies a right to nominate, that's nothing that the proxy access rule resurrects. The problem is a state law problem, and I think if I had, if I wanted to dilate on your thesis, your hypothesis, it would be to ask what the Delaware courts are going to do about bylaws that go beyond what are fairly limited restrictions on the right to nominate and begin to be more robust and limiting of proxy access candidates. And there is a standard proposition that the right to nominate is fundamental, and the right to have that right exercised is something that can't be limited by bylaws that are unreasonable. And that gets to your last question, which is who's going to decide all that? Because this is one of these wonderful areas that makes Sarah's head hot, the relation between federal and state law in the proxy area. There's a role for both, I claim, and this is one where I don't know how it's ultimately going to get resolved. I'm, of course, aware of the certification procedure, and the Division of Corporation Finance is, of course, aware of that procedure as well. And whether and when it's going to get used is going to depend on a lot of things that neither of us can really foresee.
And I would conjecture, just to follow on, it would depend in part on whether the court would accept the distinction between the right to nominate and the right to nominate on the federal proxy. If
Fair enough.
defenses are designed for one and not the other.
Fair enough. Yes, ma'am.
Well, first let me say I absolutely adore that last question, because the comment that I was going to make to Commissioner Atkins is that, you know, it's only expensive to comply with proxy access because the corporations make it expensive by doing all of this ridiculous litigation and obstruction, such as the 16 defenses that are probably found in your article. And I hope none of the attorneys for any corporation that I own stock in reads your article, though of course they will. So instead of asking that, though, I'll go to Mr. Rees and say, first of all, I agree with you about shareholder access, although just to not make you too comfortable, certainly not because I want any union-affiliated people to be on the boards. But the fact that I believe in freedom of speech, and that the money that's spent to allow shareholders to make a choice in a well-performing company or not well-performing company actually is money well spent. I do have to ask, though, what you think. The thing that makes me think twice about this is in a state like Delaware, where they've really passed some very important changes to the law that allow shareholders to put in, as you know, expense reimbursement statutes, and I believe proxy access, although I'm not a great expert on it. So it does kind of give me pause when I think of shareholders not voting these in. I realize it's early days and we don't know how many corporations are going to adopt them, but if they're not adopted and it's easy to put them on the ballot, it does seem to suggest that's a shareholder statement that, look, we don't want to be bothered or have our management bothered. This would, of course, be more directed to well-managed corporations rather than the poorly managed corporations. Do you have any comment on that in terms of private ordering?
Yes, I mean, one of the problems is that over half of all publicly traded companies have either supermajority vote requirements to make bylaw amendments as shareholders, or dual-class stock arrangements that disempower public shareholders to make those type of changes, and and then the uncertainty about how and when it would the state law concerns before Delaware had spoken on that issue. But I think the ultimate question is, do we trust shareholders to vote between two slates of directors? And I'm confident in the ability of shareholders to make that decision. And I really see proxy access as about empowering long-term shareholders as opposed to the current shareholders that use contested director elections as part of their strategies. And those are corporate raiders today. Those are the Nelson Peltzes who can afford to run a direct. I don't believe that equal access to the proxy empowers hedge funds in any way, because they can already concentrate their stakes and nominate directors. And so I see this as being something that will be a very rare tool, but it does empower a broader constituency of groups. And those groups, by the way, do have fiduciary duties, perhaps not under state corporate law, but asset managers have fiduciary duties to their clients. Pension funds have fiduciary duties to their beneficiaries. So I think this is a realm that will be used very responsibly by shareholders. And just because you haven't seen investors put these into effect through bylaw amendments, because in a way, you know, that's a long process, right? You would first have to adopt a bylaw amendment, and then you'd have to, you know, at a subsequent meeting, run a director candidate. There's limited appetite, I think, for those multi-year type of campaigns, and that's precisely why companies do things like classify their boards of directors and et cetera. So.
Well,
Yeah, go right ahead, and then I'll exercise the moderator's
Okay,
power
sorry,
to cut us
just
off.
one thing to throw in there. You know, when I put on my libertarian hat, I agree with you completely that, you know, let the chips fall where they may, let the majority of shareholders decide as between, you know, different slates or different directors. All that is great. That's the American way, you know, as long as it's in a forthright, transparent way. Like, for example, when Nelson Peltz or whoever puts his money where his mouth is and he runs a slate of directors and then let the shareholders decide. The trouble with a lot of these sort of finaglings, like what we're doing when we're going back to our whole issue of federal encroachment on state law, and like Sarah so well said, is that these things are not exactly what they seem. What they actually do, they empower particular groups to use their clout behind the scenes, basically then to wring out of directors, like we want to, you know, unionize a plant in Kalamazoo or something like that. If you don't do that, we will run, you know, a director against, you know, whoever, and so then boards tend, or the management tends to knuckle under because they want to do it. That's exactly right. But what the trouble is, shareholders will never know, right? And so the trouble is, as long as you have these types of rules that that don't provide for transparent, you know, let's have a big battle, you know, and let the chips fall where they may, you know, that ultimately the vast majority of shareholders are hurt in a situation like that. So that's my fear of the behind-the-scenes maneuvering, which already goes on all the time with respect to these precatory issues, you know, with shareholder proposals. So anyway.
Okay. Well, I want to thank the panel. I enjoyed it, and thank you for coming.
Good points. Great.